On the left is the sparse text of the Civil Rights Statute, Section 1983. On the right is the sprawling decision tree for the modern doctrine of qualified immunity. In practice, this judge-made flowchart completely eclipses the original written law. Law students spend 3 years, and practitioners spend their entire careers memorizing these extra-textual decision trees. They are trained to analyze, debate, and cite these frameworks as if the flowchart itself is the supreme law of the land. The problem with this practice is structural. American courts are commissioned strictly to interpret written law. They are explicitly denied the power to write it. Yet modern legal practice is entirely dominated by multi-part tests, tiers of scrutiny, and balancing frameworks that appear nowhere in the constitutional or statutory text. Today, modern jurisprudence has fundamentally confused the act of interpreting the law with the act of manufacturing it from scratch. The American constitutional republic is anchored on an unyielding baseline. Government is entirely the subject of law, never its original source. Law is a pre-existing rule of right. It does not find its origin in political institutions, and it cannot be manufactured by them. This structural reality is governed by an ancient maxim defining the judicial office: just dicere, non just dare. The strict province of a judge is to declare what the law is, never to give or make the law. There is a precise conceptual difference between a surveyor and an architect. A surveyor maps out, measures, and declares the pre-existing topography of the land. An architect drafts, designs, and erects entirely new structures through pure reasoning. The judiciary is commissioned exclusively to survey. To understand how modern courts operate, we have to map the absolute structural boundary between judgment and will. When courts transition from surveyors mapping the text to architects designing new legal policy, they mathematically collapse the separation of powers, and under the laws of constitutional delegation, any doctrinal framework they build is permanently void from its inception. In a free society, the mere fact that a government institution possesses the physical ability to act does not prove it has the lawful right to act. We must draw a strict line between raw power and lawful authority. Power is simply the ability to compel. A conqueror has power. An officer acting outside his jurisdiction also possesses raw power. Authority, however, is the lawful right to compel. Lawful authority is never self-generating. It does not spark into existence simply because a magistrate is present, and it cannot emerge organically through institutional repetition, usage, or custom over time. Every valid act of government must trace backward through a specific constitutional chain of custody. The Creator endows man with rights. The people possess original sovereignty. The Constitution expresses the permanent will of the people. The government derives limited powers from that Constitution, and individual officers derive their authority from those lawfully created government offices. This sequence is fixed. Every single assertion of government power must answer a threshold question. By what lawful source was this authority delegated? The sequence cannot be reversed, and it cannot bypass any step in the chain. If a judge or an officer issues an order, but that authority cannot be traced backward to a specific constitutional delegation, the authority instantly fails. Without a traceable source anchored in the constitutional text, government authority cannot be legally presumed to exist, and what cannot be lawfully presumed cannot become lawful just because the government keeps doing it. This strict chain of custody dictates exactly how a courtroom acquires the valid jurisdiction needed to hear a case. Before a court can issue a binding legal judgment, a specific sequential equation must be satisfied. Source flows to delegation, which must pass through due process to generate jurisdiction, allowing for a judgment, resulting in enforcement. Notice where due process sits in this circuit. It is not a procedural right granted by the government as a courtesy. Due process is a strict condition precedent that must be met before jurisdiction can even spark to life. It relies on settled maxims of law that are older than the Constitution itself. If the condition of due process is violated, the entire downstream flow terminates instantly. The current never reaches the jurisdiction node, rendering any subsequent judgment or attempted enforcement a permanent legal nullity. A court cannot simply declare that it possesses jurisdiction. It does not arise from judicial convenience or local practice. Jurisdiction must be earned strictly through the satisfaction of these lawful conditions. To maintain this sequence and prevent the concentration of authority, the Constitution relies on an absolute structural division of powers. The legislative power is uniquely and exclusively the power to exercise will. Will is the capacity to create law, prescribe new rules of action, and regulate the duties of citizens. The judicial power is entirely different. It is the exercise of static judgment. It possesses neither force nor will. Its sole narrow function is to declare and apply law that already exists. The constitutional framework builds a hard structural firewall between these two provinces. The legislative department shall never exercise judicial powers, and the judicial department shall never exercise legislative powers. As Alexander Hamilton observed in Federalist No. 78, every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. Because delegated power must be strictly construed, there is no such thing as interstitial lawmaking or judicial evolution. It is a mathematical impossibility for a branch to generate a power that it was never granted. The rule separating the two branches is binary. If a legal rule already existed in the explicit constitutional text, a valid statute, or inherited common law, the court merely declared existing law. If the rule did not exist until the court announced it, the court has exercised legislative will. There is no middle ground. Creation of law is legislation, and any judicial rule created out of whole cloth is a direct breach of this structural firewall. Returning to our split-screen diagram, let's apply this strict boundary test to the most prominent judge-made doctrines dominating modern jurisprudence. Take the tiers of scrutiny originating from Caroline products. This completely manufactured framework allows judges to construct layers of strict and intermediate scrutiny, balancing away explicit constitutional prohibitions if they determine the government has a compelling interest. Look at Wickard v. Filburn. The court invented the extra-textual aggregation principle to allow the federal government to regulate entirely local, non-commercial farming on private land, a rule found nowhere in the Commerce Clause. Or consider the Bivens action, where the Supreme Court outright created an implied private cause of action for damages against federal officials out of whole cloth, effectively drafting its own statute to fill a perceived policy gap. None of these multi-part tests, standards of review, or balancing frameworks exist anywhere in the written Constitution. They are pure policy architecture erected by a judiciary exercising programmatic will instead of static judgment. Activists often defend this architecture by claiming the legislature has tacitly permitted or acquiesced to judicial lawmaking by remaining silent and failing to push back. But silence cannot amend a written constitution. The law operates on a bedrock maxim, delegata potestas non potesta delegari. A delegated power cannot be re-delegated by the legislature, nor can it be quietly assumed by another branch. When courts rely on these architectures, they transition from resolving individual controversies to engineering comprehensive frameworks. They strip the Constitution of its operative meaning and replace it with their own inventions. Because all lawful authority must trace back to a superior source, a catastrophic structural failure occurs the exact moment an institution becomes the source of its own rules. When a court manufactures a legal doctrine out of whole cloth and then later adjudicates a dispute under that same doctrine, the chain of custody collapses into a closed loop. The court acts simultaneously as the author, enforcer, and reviewer of the rule. This self-contained monopoly is completely severed from the original will of the sovereign people, as expressed in the Constitution. This structural monopoly triggers a fatal due process failure by violating one of the oldest maxims in law, nemo debet esse iudex in propria causa. No man and no institution shall be a judge in its own cause. By binding citizens to rules of its own manufacture, the judiciary destroys the fundamental condition precedent for lawful jurisdiction. The court is performing an act to itself and sitting as the baseline source of its own authority. Under this self-ratifying framework, the judiciary ceases to be a servant of the law. It subverts the hierarchy and installs itself as a sovereign source of law. Judicial activists who routinely attempt to defend this architectural overreach by appealing to living constitutionalism, arguing that the law must evolve and adapt to meet modern conditions. But evolving the law through judicial construction is not an adaptation. It is a deliberate structural mechanism designed to detach institutional authority from its constitutional source. It subjects the public to a mutable, uncertain standard based entirely on institutional whim. A constitutional republic faces an absolute binary. Either courts strictly declare pre-existing law, or they usurp legislative power to create it. If they create law, they violate the separation of powers. If they judge the validity of what they created, they destroy due process. To address the status of these doctrinal frameworks, we must look to the permanent legal standard established by the United States Supreme Court in Norton v. Shelby County. The court affirmed that an unconstitutional act is not a law. It confers no rights, it imposes no duties, it affords no protection. It is, in legal contemplation, as inoperative as though it had never been passed. An act done without lawful authority cannot cure its own trespass through repetition, laches, or precedent. The ultimate question is never whether a doctrine is useful or long-standing. The inquiry is strictly about the source of the authority. Any judicial decree, balancing test, or doctrine manufactured out of whole cloth is completely inoperative and void ab initio, null from the beginning. Because authority without a traceable source to the constitutional text is not authority at all.